Hey everyone, Dan McKenzie here with McKenzie Law Firm. We are a estate planning, estate administration, and small business counsel law firm in the Denver, Colorado area. And I wanted to make a video today talking about a concept that you may have heard of if you are either making a trust or administering a trust or involved in a trust in some way. And that is the concept of a trust protector. And so if you have any familiarity with trusts at all, you know that there are usually three parties involved with any trust. There is the person making the trust, sometimes called the trustor or the settlor or the grantor. I always call it the trust maker, just to be real clear to anybody who's not, dealing with these all the time, who that person is. So that person is obviously someone who owns property, has assets, has certain things they want to have happen to those assets. They write those instructions down, and they take those assets and those instructions, they hand them over to party number two. Party number two is the trustee. Trustee's job is to receive those assets and read the instructions that they got from the trust maker and follow those instructions. And also to protect the assets and to put them to good use while they are under their control. So if they've got a stock portfolio, for instance, they got to make sure that that stock portfolio maintains some level of appropriate risk diversification, or that it's allocated correctly. If it's a rental property, they got to make sure that that property is insured, protected, kept up to date, and filled with a renter, and that the rent's being collected and all those kinds of things. So that's kind of a big job. And then they're doing all that for the third party. Party number three is the beneficiaries. That's anybody who is entitled to receive assets from this trust. And so those are the three parties that are typically involved in the trust. Now, the tricky part is that for trusts that are irrevocable, and most trusts either start off that way or eventually are going to become irrevocable, meaning that the trust maker is no longer able to change things, and the trustee is just there to execute the instructions they got from the trust maker. So as you can imagine, there are a lot of situations where it's like, oh, these instructions are now 20 years old. Like, tax laws have changed. Family situations have changed. Beneficiaries are in different circumstances than they were when this trust was created, and things have changed in some way that is really disadvantageous to everybody, right? And we need to kind of update this, but there really isn't anybody, because this trust is now irrevocable, that can do that. So what do we do? And in a lot of situations, really the only outlet to get things updated or to resolve conflicts between the parties is to go to a court and ask a court to review it and either tell the trustee they got to do things differently, or to reform the trust agreement so that it addresses the problems that arise. In a lot of situations, going to court is kind of the last thing people want to do. It's obviously can be very expensive. It usually requires lawyers. And then once you get into the court system, for better or worse, the United States court system, it's an adversarial system. It really is designed with the idea that everyone is going to come in and stand up for their own rights, and they're going to kind of fight about things, right? So, and the idea is that out of everybody protecting their own rights and kind of working against one another, out of all that conflict, the truth will emerge. And so, whatever you think about that process or whether that really works or not, that is usually what happens. So people who may not really be fighting, by the time they get into the court system, may end up fighting. And if they're already fighting, it really, the court, usually court processes do not help bring that down. So what we often will do is add a fourth position into our trust agreements. And the fourth position is this trust protector idea. And a trust protector can be filled by a specific person. There could be a process set up for appointing a person if needed. But the idea is that this trust protector is someone outside of the process. So it's not the trustee, it's not the trust maker, it's none of the beneficiaries. It's kind of a detached third party who can fill the role that a court would normally fill. And the idea is that if anybody has any issues at all, and it could be they disagree with how things are being managed, or they disagree with what the beneficiaries are asking for, or the instructions in the trust have become outdated in some way because of a change in law or a change in circumstances that we hadn't predicted, this trust protector position can be filled, and people can go into a conference room. This is usually like a lawyer or an accountant or a professional fiduciary or someone else who kind of has familiarity with how these things work. And the people involved in the trust, the trustee, the beneficiaries, would kind of go to that person's office and maybe have something resembling more of a conversation, depending on how things are going or what the dispute is or why they're there. And that trust protector can hear them out and kind of be deputized to do things that a court would normally do. And the idea is that maybe the trust protector could do this without all of the process and expense and lawyering that needs to be done once people are in court. And it's sort of like a lot of my clients kind of analogize it to maybe like a private mediation or an arbitration or some sort of alternative dispute process. And yeah, I think that's what it is. And the idea is that this trust protector would step in, they'd hear whatever's going on, they would do what they need to do, whether that's reforming the trust agreement, telling the trustee what to invest differently if that's the concern, or to give the beneficiaries whatever they're asking for if that's the concern, or tell the beneficiaries that what they're asking for is not authorized by the agreement, whatever, all those things that can happen when trusts age and beneficiaries age and their circumstances change. The trust protector, unlike the trustee, can actually go in and give an outsider's perspective and tell everyone involved, here's what we're going to do. And so we like it. We think it's helpful. Sometimes we get clients who kind of see it and think, well, I don't necessarily want a third party coming in here and changing this, especially if I don't know who that would be. And I always point out, well, a court is a third party, and they're always going to be, they're always available to potentially change terms of trust. And at least with the trust protector, you can kind of specify, here's how I want that done, here's how I want to do this position, or here's how I want this person picked. So it gives you some control over making sure that this doesn't spin out of control in some way, which when you get into court, you just never really know what's going to happen. So when I'm administering trusts, especially if there seems to be a dispute arising, I always check to see, is a trust protector available? Is there someone out there who could fill this position? And when the answer is yes, I usually kind of breathe a sigh of relief because I think it's very helpful. So if you are putting together a trust and are interested in this concept and how it might fit in, or if you're involved in some sort of, in a trust in some way and are worried about a dispute or something like that and would like to discuss this, happy to do so. Again, we are the McKenzie Law Firm. Phone number is 303-578-2745, and I appreciate you watching this video, and I hope this was helpful. Thank you.